Wouldn't start. I had to push it to the top of my driveway. So I'm out there pushing the car. It seems like every time I take one step, I take 2 steps backwards because I'm trying to push my car uphill. Next thing I know, Hannah's out there helping me push my car. And she's like, "Why didn't you tell me, Mr. Victor, that you're out here pushing your car?" I say, I didn't think about that. And like I say, I've known Hannah since day one. I've known her family since day one. And you can see, but anyway, Hannah, she was just the type of person that she didn't mind helping you. And she didn't care what it was. Things, I'm not very good on a computer. I got a race car that I was trying to program. I said, "Hannah, can you help me out?" She came over there. I don't know what she was doing. Maybe she was in the middle of dinner. Came over there and helped me program a car because I didn't know how to do it. And just like I say, I'm not much of a speaker. That's all I have to say.
And sir, about the sentencing of Ms. Payne, do you have anything to say about that?
I don't have anything to say about that. I know what she did was wrong, and she thought about it, she would do it again. I would hate to lose a family member, but I would like to say that the family would have some leniency against her. I know what she did was wrong, and I know a lot of times we do things, we don't make the right decisions. Everybody's guilty of that. He who is without sin cast the first stone.
Thank you, sir. Yes, sir. And this will be my arguments and statements. I believe the state.
The state goes first.
Okay.
Judge, obviously you sat through this trial and heard the entirety of the evidence in this case. This is not a jury that struggled. They never once indicated that they could not reach a decision. They barely took 2 hours to find the defendant guilty of all charges, including malice murder. The evidence was overwhelming, and the jury was very comfortable in finding that malice. I want to address one thing, and I know it's an uncomfortable thing for everybody to address, but the state and my office has never once made this case about race. Not one time. We did not ask a single question in jury selection that would be considered race baiting. We did not say anything about race throughout this trial. We just have a community that we represent that needs peace and needs healing, and has needed that peace and needed that healing over and over and over again, whether it's aimed at this defendant or not. So whether or not we would be in this same place if Mr. Herring looked different, that's something only the defendant in her heart can speak to. But we have not made this case about race. But we do want this case to be about Mr. Herring and this defendant. Mr. Herring was a human worthy of saving. He had a family to go home to. And what he wanted and his wishes and his rights were fully disregarded by this defendant on May the 7th of 2019. We've talked about the witnesses, and I respect their opinion. I know they've known the defendant for a long time. But I want this court to consider what you've really heard about the real Hannah Payne. Her demeanor in this courtroom, her demeanor during her cross-examination, where she was as disrespectful as she could be, only remembered answers to her lawyer's questions. Her demeanor and who the real Hannah Payne is was heard in that 911 call. When she decided that she's smarter and righter than everyone else. She was told repeatedly, even though she's been, in my opinion, dishonest about it, she was told repeatedly and understood clearly to leave Mr. Herring alone. The real Hannah Payne is the one screaming on that call for him to get out of the car and cursing at him and striking him, as every state's witness who witnessed that incident told you about. The one who introduced a gun into a situation that had nothing to do with her. And then has continued to fail to accept any responsibility for her actions whatsoever by trying to claim that Mr. Herring shot himself, when the evidence is clear that that's not what happened, and honestly not really possible. She has yet to tell a consistent story about what happened. Every time she told the story in her interview, it changed. It was different here. It was different in the back of the patrol car, because she accepts no responsibility for her own actions. The real Hannah Payne is the one cursing, telling him to get the F out of the car. And when she gets back on the phone with 911, explaining that she shot him because he hit her Jeep. He hit her car. The real Hannah Payne is the person who said, "I'm safe, but he ain't." That's the malice that the jury heard, and what they had no problem finding beyond a reasonable doubt that was in this defendant's heart when she took the life of a big brother who gave all his siblings nicknames and made jokes with them and took care of them and put himself on the mountain to take care of his whole family. We do not believe, Judge, that this is a case where the minimum sentence is appropriate based on all of these factors. There has not yet been a tear for this victim. Her tears are for herself. You have the authority in count 1 to sentence the defendant to life without parole as requested by the family. And we would ask that you consider their request and leave the choice as to whether or not the life is with or without parole in the discretion of this court. However, on the false imprisonment, if this court does choose to give this defendant life with the possibility of parole, it is the state's request that the 10 years on that false imprisonment run consecutive on count 5. And then on count 6, you are required to give a consecutive 5-year sentence. And we would ask that it run consecutive to the false imprisonment for a sentence of life plus a consecutive 15 years. We will leave it within this court's discretion as to whether or not you think this defendant deserves a sentence of life with or without parole, but we would ask that you consider the statements made by the family in this case and the things that you have heard in this trial and the malice in this defendant's heart. Thank you.
Thank you, Chief Assistant Smith. Attorney Tucker.
I'm going to do this over a little bit more so I can speak without the mask. Judge, that is true. When we started this case, I think you came in with a narrow approach of it, not to let the media try to guide your understanding of what was going on. Came with open mind, open eyes, wanting to see what was going on. And throughout the course of the trial, there were inconsistencies. I mean, the state's saying it was with my client. I'm saying it was with their witnesses. I don't think we heard really anything from the witnesses that matched up with what we could conclude happened. And during that process, there were lots of things brought up and a lot of unnecessary biases added to their statements. As for disrespectful, you know, I felt the witnesses were disrespectful. I don't think any of the witnesses gave the respect they should have to the court and to the court officers. But that's part of what happens when you're in a trial. As for Ms. Payne, I think you heard her on the stand when asked, is there anything you could go back you would change? And she kind of dropped her head and said, you know what? I wouldn't even helped out at the beginning. I would not have listened to that state officer and tried to help out. And that's a shame that somebody who has good in their heart is no longer ever going to want to help anybody because, for lack of a better saying, no good deed goes unpunished. But that was a decision she made, and a decision that, you know, her upbringing, her standards, her values put her in that situation. And that decision is what got us here today. And that decision, according to the jury, is wrong. And just because it was a bad decision doesn't make her a bad person. It just makes her human. And we all are human. And she is young in age. And I believe the state's assessment is correct about what charges would merge with which ones. With malice murder, even though we agree to disagree, I just did not hear elements that would do that, and maybe it's because I know Hannah from the 4 years we've been preparing for this. But to give her life without parole is to take a person who had good in her heart and tell her you'll never get a chance to get back out and get that good back. So we would respectfully request that the court look back at what all was said, look back at what all was done and was brought forth, and fully understand she never intended anything that day when she left from work to end up being there, to be in a struggle with Mr. Herring, to be on the side of the road, to have to pull her gun to protect herself and the gun going off. There was never any intent to have that. It was an accident. And by the grace of God, when it did, she wasn't shot by it, and it was terrible and a tragedy that Mr. Herring was. But, you know, she is a young person who has plenty of life ahead of her. We just hope that the court would use the discretion to allow her to have some of that life to continue. The charge number 5, the false imprisonment, it does say it could be run concurrent or it could be run consecutive, but it also says it can be probated. And the 5 years for the gun can be probated. And I think the court would hopefully look into what has been said today from both sides. Unfortunately, I was not able to speak with the jurors to see what their mindset was, to find out conclusively, was it dead set because the facts were overwhelming, or was it something they discussed? So I really can't go into details of what the jury said. I just can go in what I heard and wrote down, and I saw you making numerous notes. And I would hope the court would use those notes in coming to the decision to sentence her to life with parole and allow the other two, well, the one charge to be run concurrent, the other one has to be consecutive. Our hands are kind of tied on that. But understand that, you know, this was all done with good intentions. And I know they say the road to hell is paved with good intentions, but she's never seen that road. She's never seen what happens out there in car accidents and arguments and walking up on cars in Clayton County. And to sentence somebody to life without parole for being naive or trying to do something with the goodness of a heart, I think is a little bit harsher than what is necessary in this case. And I would just put it to the court to use the facts that they've heard and the direction that is given to them by the law and the compassion that we know is in your heart, and allow her to have parole and have an opportunity to show that it was just a bad decision. She's just human. Decisions can be changed by the way people handle adversity, which is what she's going to be dealing with here, and give her a chance to show that she does have good in her heart and that she does know certain things you can't do. And no matter if it feels right to do it, you just can't do it. And I don't think she'll ever step up to help again. And that's a tragedy in itself, not to the magnitude of losing a loved one. But if the court could take that in consideration of her age, the facts, the compassion, and sentence her to life with parole, and have the other charge run concurrent, and probate that gun charge, I think it would allow her time to reflect, to fully understand that things happen and it can be found to be wronged, but it's how you handle yourself through that adversity to get through it and come back and show the true you is what allows us to keep hope in our heart and allows us to keep going. Thank you, Your Honor.
Thank you, Attorney Tucker. From the state?
I believe in this hearing, the defense is entitled to the last word.
Okay, the court having heard from the witnesses and from the attorneys, I am required to take a short recess to consider, which is what I'm going to do at this time, and I will return with respect to what my sentence will be. Thank you. Okay. This court has sat through the trial, has heard arguments of defense and the state, has listened to the witnesses today, and after considering all of those things, the court will impose sentence as follows. Please stand, Ms. Payne. With respect to count 1, malice murder, the court will impose a sentence of life with a possibility of parole. With respect to count 2, felony murder, that will merge into count 1 and is dismissed as a matter of law. With respect to count 3, aggravated assault, that merges into counts 1 and 2. With respect to count 4, felony murder, that merges into count 1 and it is dismissed as a matter of law. With respect to count 5, the false imprisonment verdict, the court imposes a sentence of 8 years consecutive. With respect to count 6, possession of a firearm during the commission of a felony, the court imposes a sentence of 5 years that will run consecutive to the underlying sentence. Count 7 and 8 will merge into count 6. So the court's total sentence is life with the possibility of parole plus 8 years consecutive on the false imprisonment and 5 years consecutive on the possession of firearm during the commission of a felony. And that is the court sentence. So I'll remand you again, Ms. Payne, into the custody of the Sheriff's Department. Before I do have some instructions for you, Ms. Payne. You have a right to seek post-judgment relief from your conviction of the crimes either by making a motion for a new trial in this court and or filing an appeal to a higher appellate court. If you want to file a motion for new trial or an appeal, then you will need to file the said motion or a notice of appeal with the clerk of Superior Court of this county within 30 days. You may want to more fully discuss this with your attorney. If a motion for new trial is made and the court denies it, you will have 30 days from the filing of this order of denial in which to file with the clerk of court your notice of appeal. You have a right to have an attorney represent you on the motion for new trial and the first level of direct appellate review. And if you cannot afford to hire an attorney, the court will provide you an attorney and a transcript of your trial at no cost. In addition, usually you have a period of 4 years from the date of your sentence, which is today, before in this court becomes final to file a habeas corpus petition. The details that can affect the time within which you must file this petition are contained in the copy of this code subsection, and I'm going to ask the deputies to hand that to you. And so you have 4 years from today's date to file a habeas corpus petition. Councils, I can confer with you as to set in a date for the hearing for a motion for new trial, but we can do that once we're adjourned. Okay. Deputy, did you have that?
I just have one question after this name.
Yes.
I noticed you said 8 and 5. Are any of those additional charges, or any of that going to be probated?
I believe I was very clear, Attorney Tucker, that they're consecutive.
So it's consecutive to serve?
The life with the possibility of parole. Okay. Anything further from the state?
Nothing further from the state, Judge.
Anything further from defense counsel?
Further from the defense.
Okay, thank you. Ms. Payne, you may go with the deputies at this time. With respect to this matter, the court stands adjourned at this time.